The Bramble Bush. 1. What law is about. You have come to this school to embark upon the study of the law. Most of you have in the back of your heads an idea that as a result of that study, you will become lawyers. Some of you have some notion of what it is that a lawyer does. You think of a man who tries cases before courts. Or do you think particularly of a man to whom to turn in case, for any reason, you happen to get arrested? But what a court does, what a lawyer does in court, and what he does outside, what relationship either court or lawyer has to the law, what relation the law school has to any of these things around these things, I take it, there floats a pleasant haze. If it were not pleasant, you would not be here. Perhaps you would not, if there were no haze. What I propose to do is to take up successively a series of questions. First, and today, what is this law about, which you propose to study? Second, and tomorrow, what is the machinery for going about this study? What are you going to have to do in this school, and how can you best go about doing it? Third, what are the opportunities that the school offers, and what are some of the problems that you will have to solve here, and what are some of the ways of their solution? And lastly, how does the study of the law here bear upon the work that you will do, and the life that you will live when you leave this school and go into the practice? We have no great illusions, my brethren and I, as to how much good it will do you to be told these things in advance. We have learned by bitter experience that you will not take the things we tell you very seriously. You conceive this, I take it, to be somewhat in the nature of the pep meeting to which you were exposed when you first entered college. You expect me to tell you that you should be earnest about your work, and get your back into it for dear old Siwash, and that he who lets work slide will stumble by the way. You sit back with a cynical detachment, prepared in advance to let this anticipatory jawing slide comfortably off your neck and rump. Let him have his say. That is what he gets his pay for. But we, the sophisticated youth of this new century, we know that he means little of what he says, and what he does mean, as far as he is concerned, means nothing to us. The ungovernable hand of fate has put him in the chair. No help for that. The workings of society require us to let his mouthings fan our ears. Another of the conditions to admission to the bar. We have, I say, no great illusions as to how much good this talking at you is to do. Still, we must perform our duty as we see it. Not only that, but after some sweat of spirit we have arrived at the conclusion that some things need saying, even to the willful deaf. They shall be said. There is yet another thing upon which experience long and sad has caused us disillusion. We have discovered in our teaching of the law that general propositions are empty. We have discovered that students who come eager to learn the rules, and who do learn them, and who learn nothing more, will take away the shell and not the substance. We have discovered that rules alone, mere forms of words, are worthless. We have learned that the concrete instance, the heaping up of concrete instances, the present vital memory of a multitude of concrete instances, is necessary in order to make any general proposition, be it rule of law or any other, mean anything at all. Without the concrete instances, the general proposition is baggage, impedimenta, stuff about the feet. It not only does not help, it hinders. And since what I am to say to you is said while there is vacuum in your heads, the likelihood of its taking hold, or its taking on meaning, of its having utility for you at the present time, is very slight. It would be slight enough if you had any will to hear. Yet it needs saying. It needs saying because there is great joy in heaven when even one lost sheep is gathered to the fold. It needs saying because there is always an odd chance worth 8 hours of your time and mine, that something of what is said may stick long enough to be on hand when the concrete problems do develop before you, on hand to help your thinking when they come. What, then, is this law business about? It is about the fact that our society is honeycombed with disputes. Disputes actual and potential. Disputes to be settled and disputes to be prevented. Both appealing to law, both making up the business of the law. But obviously those which most violently call for attention are the actual disputes, and to these our first attention must be directed. Actual disputes call for somebody to do something about them. First, so that there may be peace, for the disputants. For other persons whose ears and toes disputants are disturbing. And secondly, so that the dispute may really be put at rest, which means so that a solution may be achieved which, at least in the main, is bearable to the parties and not disgusting to the lookers on. This doing of something about disputes, this doing of it reasonably, is the business of law. And the people who have the doing in charge, whether they be judges or sheriffs or clerks or jailers or lawyers, are officials of the law. What these officials do about disputes is, to my mind, the law itself. There are not so many, I think, who would agree with me in thus regarding law. It is much more common to approach the law as being a set of rules of conduct, and most thinkers would say rules of external conduct to distinguish them from the rules of morality. Be good, sweet maid, and let who will be clever. And most of the thinkers would probably say rules enforced by external constraint, to distinguish them not only from rules of morality, but also from some phases of custom, such as wearing ties and Paris garters. And many thinkers would add, rules laid down by the state, in order to distinguish them from the commands of a father, or the regulations of a university, or the compulsion to be a Democrat in Georgia. Most thinkers, too, would take these rules as addressed to the man on the street, and as telling him what to do and what not to do. To most thinkers, I say, rules are the heart of law, and the arrangement of rules in orderly, coherent system is the business of the legal scholar. An argument in terms of rules, the drawing of a neat solution from a rule to fit the case in hand, that is the business of the judge and of the advocate, all of which seems to me rather sadly misleading. There is indeed much, in some part of law, to be said for this view that rules laid down for conduct are the focus, quite apart from disputes. Rules that everyone's income tax return must be made out on the same type of form do not look to disputes so much as to convenience of administration. Rules as to fencing elevator shafts look primarily to avoiding not disputes, but injuries, and indeed it may properly be said that as civilization grows more complex, there is a widening slice of law in which disputes as such sink out of sight, and the focus of law becomes the arrangement or rearrangement of business or conduct to get things done more quickly, more easily, more safely. It may properly be said that in many such cases there is not even as there is in requiring travel on the left side of the road or on the right, or in fixing the one effective form for validating will or deed a purpose of dispute avoidance running beside the purpose of convenience. It may properly be said, finally, that even where the purpose clearly is dispute avoidance, that purpose in turn often sinks into the background, and men talk about contracts and trusts and corporations as if these things existed in themselves, instead of being the shadows cast across the front stage by the movements of the courts unheeded in the rear. All of this, however, goes not so much to the importance of rules as to the non-exclusive importance of disputes. Whether about disputes, or about when wills are valid, or about the form for income tax reports, we come back always to one common feature. The main thing is what officials are going to do. And so to my mind, the main thing is seeing what officials do about disputes or about anything else, and seeing that there is a certain regularity in their doing, a regularity which makes possible prediction of what they and other officials are about to do tomorrow. In many cases that prediction cannot be wholly certain. Then you have room for something else. Another main thing for the lawyer, the study of how to make the official do what you would like to have him. At that point, rules loom into importance. Great importance. For judges think that they must follow rules, and people highly approve of that thinking. So that the getting of the judge to do a thing is in considerable measure the art of finding what rules are available to urge upon him, and of how to urge them to accomplish your result. In considerable measure, rules, too, then, and their arrangement, and their logical manipulation, make up an unmistakable portion of the business of the law and of the lawyer, in any event. And whether I am right or whether I am wrong in this analysis, it is certain that you will spend much of your time attempting to discover, and to study, and to remember, and to see the meaning of these so-called rules of law, which judges say they are bound by, which judges say they have to apply. If I am wrong, you can perhaps rest content when you have found out what the judges say. If I am wrong, you can believe what they say and be happy. But if I am right, finding out what the judges say is but the beginning of your task. You will have to take what they say and compare it with what they do. You will have to see whether what they say matches with what they do. You will have to be distrustful of whether they themselves know any better than other men the ways of their own doing, and of whether they describe it accurately, even if they know it. Nor is this all. If I am right, you will also have to look into the question of what difference what the judges do is going to make to you, or to your client, or to any other person who may be affected by the judge's rulings on disputes. And even that will not be all. For when you find out what difference the judge's acts will make, you will then be confronted with the task of figuring what you, or your client, are to do about it. If the judges say a contract with your buyer that he will not resell below a certain price will be illegal and not enforceable, if they are likely to fine you or send you to jail for making such a contract, but you still want your goods resold throughout the country at a single price, what can you do? That is a problem for invention, for ingenuity. The problem of inventing a method of action which will keep you free of difficulty and will produce the results you want in spite, if you please, of what the judges in a case of dispute may be expected to do. If I am right, in a word, the action of the judges past and prospective becomes a piece of your environment, a condition of your living, like the use of money, with which you must reckon if you want to get where you would go to. And you cannot then rest content upon their words. It will be their action, and the available means of influencing their action, or of arranging your affairs with reference to their action, which make up the law you have to study. And rules, in all of this, are important to you so far as they help you see or predict what judges will do, or so far as they help you get judges to do something. That is their importance. That is all their importance, except as pretty playthings. But you will discover that you can no more afford to overlook them than you can afford to stop with having learned their words. You will have noted, I hope, that I have been talking chiefly about disputes, whereas the ordinary man's thinking about law is in terms of axe murderer breaks up love nest, or of bobbed-haired bandit loots 3 banks, or at the very least of Mr. D. Volstead. But as a matter of logic, crime, and those who commit crime, and the conviction or acquittal of those who say that they have not committed crime, although the district attorney alleges savagely they have, all belong under the head of disputes. As a matter of logic, they are but one such class of disputes, those which are deemed to affect less 2 particular private parties, who may be incidentally concerned, than they affect the whole body of the public, as represented by the state officials. Not merely as a matter of logic, but as a matter of practical importance, disputes is a larger and more important category than the category crimes. The criminal business of the courts bulks large, yes, but in terms of quantity, it does not bulk so large as the civil business. We can afford, therefore, to think of law as relating primarily to disputes, and to think of crimes as only one piece of the business of the law. On the other hand, crimes are a peculiarly important piece of that business. They are the piece which it seems so essential to deal with that we do not always wait for the aggrieved party to act before the state official steps in. That indeed we do not trust the aggrieved party to handle the affair, even when he has made a complaint. So that if you have looked over the list of courses offered in the school, it may already have struck you as somewhat strange that you find but one course in the undergraduate curriculum allotted to this whole field of crime, while all the rest is taken up with the civil side of law. I suppose that the reason for this somewhat astounding fact is that we expect very few of you to practice on the criminal side. Some of you, to be sure, and especially those who have some ambitions in a political way, may for a time go into the public prosecutor's office. A few of you may go further and undertake to emulate the noted defenders of those accused of crime. But in the main, it will be an accident if 5% of you touch criminal practice more than incidentally in the course of your professional careers. That is more than regrettable, as it is also regrettable that the criminal bar in the large enjoys anything but an enviable reputation. But regrettability does not change conditions. and I surmise that the curriculum has been constructed with reference to conditions and not with reference to regrettabilities. But I should say here, as I shall say again, that whatever the nature of your prospective practice, it would be a misfortune for you, and for us, and for the public whom you, supposedly, will later service, if you were to confine your training in this school to what I may describe as bread and butter courses, to those which seem to you of most immediate practical importance, to those which you conceive adapted to butter your bread, or to give you bread to butter. At this stage of the game, I wish to do no more than to indicate one of the huge discrepancies between the setup of the law curriculum and the importance of law in life. In the world outside, the criminal law cuts to the essence of things legal. In the law school curriculum, it appears almost as an excrescence upon the body of the private law. There are reasons for this which are defensible. But one thing I would drive home before you begin your study, that it will not do to take your picture of the importance of the law to society or of the relative importance of various fields of the law from any law curriculum alone. Within the field of civil law, however, it may well be that the divisions of the law curriculum afford a more trustworthy guide to actual importance. And no division is more vital or more necessary for your immediate understanding than that between so-called substantive law and so-called adjective, i.e. procedural law. The idea behind that division is something like this: that certain bodies of law, which we call substantive, the substance of the law, deal with what ought to be, with whether contracts ought to be enforced at law, and when, with what formalities are necessary to make a last will stick, with how to form a corporation and how to issue its stock, and how to keep investors from having any say in it, with what words are necessary to make an effective lease or deed of land, and so on. The idea, so far as I get it, is that these are matters which can be thrashed out without immediate reference to the courts, that these are matters which can be determined, and are determined in terms of what ought to happen, and that rules can be laid down by legislatures or by courts, and are making clear what ought to happen in such cases. Adjective law, on the other hand, is supposed to be the mere regulation of the work of the courts. The business procedure, if you please, by which they go about doing what they ought to do, and go about solving disputes to ends already indicated by the substance of the law. That some procedure is necessary should be fairly obvious. There may once have been a society so simple that all one had to do when there was a dispute was to go up to Uncle Obadiah, pull him away from his plow for 10 minutes, talk the matter over, and listen to what he had to say. But when there are enough disputes to take up all the time of 10 or 1,000 Uncle Obadiahs, an order of business becomes necessary. We cannot all run in on the same judge at once, or none of us will get our business done. We cannot even all run in upon the particular judge who has been assigned to our case, or most of us will sit around for 3 weeks waiting for the others to have their cases heard. Moreover, there are defendants who will not be willing to come to court with us when we have a dispute against them, and there must be some regular procedure for getting them there, and some regular means for letting them know what the row is about. Indeed, there is some importance in getting the disputes fairly well stated in advance, so that the judge, too, will know what the row is about. And so it goes. To economize the time of judges and parties, to make the issues clear in advance, to give due notice and due chance for a hearing to defendants, and again due notice and chance for a hearing to plaintiffs in regard to what defendants claim by way of a defense, to make the trial itself orderly, again to economize time and make regular and fair the presentation of the case to an upper court, when one side claims that the lower court has not acted according to the proper rule. Finally, to have a record of just what dispute was litigated, so as to prevent its being brought up a second time. These things make up procedure. And from one angle, it is perfectly clear that this procedure has nothing whatever to do with the subject matter, the substance of the dispute, nor with a desirable way of deciding it. From one angle, I say, it is clear that procedure has nothing whatever to do with substantive law. For these reasons, it is worthwhile to take a distinction between the two. It is worthwhile to mark off a course in procedure, a course in trial practice, a course in evidence, and set them apart as technical studies which run free of any particular substantive subject matter. From this angle, these procedure courses appear as the technical tools of the trade and nothing more. As books of etiquette through which one learns to use the legal oyster fork for legal oysters, and to avoid the knife when picking bones from legal fish. But from another angle, this distinction tends to disappear. For if you whistle your soup, you may be looked at queerly, you may be laughed at. You may even fail to be invited out again another time. But if you slip in your legal etiquette, it is not a question of queer looks or laughter, or of what may happen later. It is likely to cost you your case right here and now. Your case and your client's case. The lawyer's slip in etiquette is the client's ruin. From this angle, I say procedural regulations are the door, and the only door, to make real what is laid down by substantive law. Procedural regulations enter into and condition all substantive laws becoming actual when there is a dispute. Again, this is no reason for not marking off procedure and evidence and trial practice as fields for special and peculiar study apart from substantive law. They should be marked off. They should be marked off for the most intensive study. But they should be so marked off not because they are really separate, but because they are of such transcendent importance as to need special emphasis. They should be marked off not to be kept apart and distinct, but solely in order that they may be more firmly learned, more firmly ingrained into the student as conditioning the existence of any substantive law at all. Everything that you know of procedure, you must carry into every substantive course. You must read each substantive course, so to speak, through the spectacles of the procedure. For what substantive law says should be means nothing, except in terms of what procedure says that you can make real. You will have observed that I do not take too much stock in this demarcation of substantive law from adjective, as meaning much. I see the distinction as offering simply a certain convenience in one's thinking. Substantive law presents the problem of where officials would like to get with a problem, and of where they say that they are going to get either because they want to, or because tradition forces them. But discussions of substantive law become so easily misleading. One falls so easily into thinking that because he would like to get somewhere, he has arrived. If wishes were horses, then beggars would ride. If rules were results, there would be little need of lawyers. Nonetheless, the demarcation is convenient, and convenient especially to help classify the types of problem law must reckon with. So too, within substantive law, one can make various rough groupings for convenience. I suppose the most vital one is that between what we call public and what we call private law. Public law is that part of law which deals with the framework of the state, the operations of the state, and the more direct relations between the state and the individual, or the various groups of individuals like corporations. The Constitution states the framework for all our law. Legislation is one great tool of legal change and readaptation. The administrative officer, from the Secretary of the Treasury issuing regulations on income taxes down to the traffic policeman with his stop and go, affects the lives of each of us, and is, to that extent, the state itself. The study of their work is public law, and into the field of public law of course go crime and all dealing with crime. In this first year you meet public law only in the second semester when you take up the process and interpretation of legislation, and the criminal law. You begin essentially on the other side, the private side, the side of the legal relations between individuals. And perhaps this is well, precisely because that is the side of law with which you have thus far been least concerned. The field of private law can be split, perhaps, into four grand divisions of major importance. The first is that of contracts, of agreements between people and the legal effects of such agreements. This is the branch of law which plays primarily into what economists know as the market, the balance wheel of a money economy, the social machine which makes possible our regime of specialization. The second grand division is the law of property, and more particularly the law of real property of land. Here one goes into the fact behind the economist's theory of value, the fact of scarcity, and into its legal side, to wit, the monopoly of the things which are scarce, T is hardly necessary to point out that so far as the state safeguards such a monopoly, and at the same time makes possible the free transfer of the things monopolized, it sets the framework within which the market, the agreement, the contract moves. And that exchange is possible only within the limitations thus set, and with the advantages thus created for some men over others, and along the lines and by way of the devices which law officers lay down. The third great field of private law I suspect to be that of associations, and the ways in which men can come together in groups to accomplish their purposes, and of the limitations as well as the powers which legal officers place upon the activities of such groups. At this point, the law plays especially into the phase of economic life we know as industrialism, of capital aggregation, and the concomitants thereof, the labor organizations. The fourth major field I take to be the leftovers, and more particularly, the attempted general regulation of matters in the field of free play, which fall outside of the field of agreement. There are contacts which cause trouble, but which were not intended or agreed upon the motor accident. There are aggressions which raise problems not only of the criminal law, but of compensation for the damage caused. There are uses of land, as for a soap factory in a residence district, which are obnoxious to the neighborhood. There are instances of competition carried too far, which call for regulation or for compensation. A good part of this we lump together under the head of torts of private wrongs. I do not mean in this classification to make mutually exclusive groups. The heads are convenient for description, not the framework of a logical system. Things overlap. Associations, e.g., are formed by contract and hold land. Property is transferred by contract, and there are torts peculiarly connected with property. Some torts arise either out of contract or out of interference with contract. Some of the most puzzling questions of tort law deal with associations. The suggestion is therefore not of mutual exclusiveness, but rather of striking divergence of focus. Neither do I mean to suggest that all private law can conveniently be brought under one or another of these main heads. I know of some topics which I should find a good deal of difficulty in assigning to one rather than another of the heads, or in assigning to any one of them at all. But that, too, is of small import, if the heads are sufficient to give you some rough picture of how the bulk of private law divides, the bulk of private law, I mean to say, in its importance to the community. There is, for example, a huge number of legal rules relating to the family, which you will observe that I have not mentioned at all, and did not think I needed to. For I suspect that the thing which marks those rules off rather strikingly from those I have been attempting to classify is the fact that in the main, the rules of family law are of relatively little importance to family life, whereas the rules on economic life play a very considerable part in business living. Thus far I have told you that what law was about was the dealing with disputes, that it was made up largely of what officials do about disputes, that the rules of law were important in so far as they give us a guide to what the officials will do, or to how we can get them to do something. And then I have told you a little of the main divisions of the subject matter of law, into substantive law and procedure on the one hand, and into public law and private law on the other. And I trust that it has become clear that the law curriculum, while it gives considerable attention both to procedure and to public law, still puts its major emphasis upon private law on the one hand, and substantive law on the other. All this only presents the setting for the final thing I wanted to talk about today, to wit, what does this law business really come to? What does it mean to people in society? In a word, what difference does it make whether or not there are any courts or lawyers or law schools or law students? The first difference I suppose that it makes is that the removal of all these would somewhat add to the current crowd of unemployed. Perhaps it is harsh to a high profession to urge that by itself is no particular reason for the existence of courts and lawyers. Nevertheless, I shall take the position that a job needs some further justification than the fact that if it is present someone can make a living holding the job down. Which brings us back to the problem. What difference do courts and lawyers make? For you will observe that it is not enough to say merely that they deal with disputes, because there are so many disputes they do not deal with. That little difference of opinion with your father, as to whether you should go to Chicago or Harvard, or as to how much your monthly check should be was not, I take it, settled by a court or by a lawyer. The higgling of the market presents a constant series of disputes that reach their adjustment by negotiation and by bargaining. Rancorous rivalries between competing firms are worked out mostly by skill and by endurance, with no appeal to law. Strikes are called and fought through and settled. Often some phases of them reach the courts. Often none do. Almost never does the main question in a strike occupy a court. But perhaps the case of the strike is as good as any to bring out the part that law does play. Law, in the person of judges, police, and sheriffs, does lay down rules within which strike and lockout and struggle of employer and employee are to be worked out. Rules of the game. No beating, no shooting, no intimidation, no blacklisting. Does it follow that these rules of the game are always observed? It does not. The games are few in number in which the rules are always observed. But what is vital is to see that the law official functions somewhat like an umpire in attempting to see that they are. Somewhat like an umpire, but not wholly. Like an umpire in that he does not always see the breach of the rules. Like an umpire in that at times he is severely partial to one side, or stubborn, or ignorant, or ill-tempered. Like an umpire, at least on the criminal side, in that he reaches in to decide and control on his own motion. But on the civil side, on the side of private law, less like an umpire in this, that he does not reach in on his own motion, but waits to be called upon. Always, however, and on both civil and criminal sides, like an umpire, I repeat, in that when acting he tries in the main, and in the main with some success, to insist that the rules of the game shall be abided by, in that he takes the rules of the game in the main not from his own inner consciousness, but from existing practice, and again in the main from authoritative sources, which in the case of the law are largely statutes and the decisions of the courts. Like an umpire finally in that his decision is made only after the event, and that play is held up while he is making it, and that he is cursed roundly by the losing party and gets little enough thanks from the winner. But whereas a ball game is tightly organized and must move swiftly, society at large is loosely organized. So loosely that individual disputes do not in the main hold up the workings of the whole. It is not therefore necessary for the law official, save at a crowded traffic corner, to be on hand announcing the rules, applying them to particular situations all the time. For the bulk of the disputes of life, he can simply wait, and be sure that sooner or later the parties will iron their own difficulties out with no need to call upon him. Law and the law official are not therefore in one real sense what makes order in society. For them society is given and order is given because society is given. Apart from order, there is no meaning in that word. Furthermore, most minor maladjustments and readjustments of order work out in one way or another without calling on the law official. They are not worked out without suffering. Overproduction means unemployment. But worked out in the main they are. The law, then, the interference of officials in disputes, appears as the means of dealing with disputes which do not otherwise get settled. Less as making order than as maintaining order when it has gotten out of order. This is its first aspect, its most ancient aspect, its fundamental aspect. But you cannot have officials to be appealed to. You cannot have them acting in fairly regular and predictable ways, without a great many people finding it desirable and useful to orient their action in advance to what the officials will do if they do happen ever to be called upon. I spoke before of the law as a part of your environment, like the weather or the party system. As long as the officials are present and capable of being called upon, you must reckon with them. What they will do shapes what you can do. What they do shapes how you can effectively go about getting what you want. You must chart your course to keep free of trouble with them, if a dispute should arise. You can perhaps chart your course so that, if they are called upon, they will be for you and not against you. You can so shape your bargain as to thrust the legal risks upon the other party. And is it not clear that, to the extent that lawyers and their clients, and even men who might be clients, but who have no lawyers, shape their conduct with an eye to what the courts would do if they were called upon, To that extent, the court decision reaches out beyond the individual case and enters into molding and channeling the action of the community. It ceases to be merely a regulation of actual disputes and becomes a regulation, and if all goes well, an anticipation and prevention of potential disputes vastly greater in number than the actual. It ceases to function merely as a last resort machinery to take care of disputes that by no other means work out to settlement, and becomes indirectly, but potentially a factor in regulating what people do before disputes, how people actually go about their ordinary business, and at times even where there are legal prohibitions, what businesses people go about. And it is this fact that people in some important measure orient their action to the possible action of officials, which makes legislation such a valuable tool of social readjustment. For legislation is an authoritative command to the official, whether judicial or executive, henceforward to act in new described ways, whenever a certain type of case may come before him. Or, in the case of legislation on crimes, even a command to some officials to hunt up some new types of case which they had theretofore been told to let alone. These commands are public, they can be learned of by the interested parties. And to a large degree the interested parties foresee what the officials will now do, and reshape their own affairs in consequence. You may have missed in this discussion the common idea that the law is right, that rules of law are to be obeyed because they are right, that men have duties to uphold the law. Such ideas are not missing because they have been overlooked. They are left out because you may fairly be expected to be well aware of them already. They are left out, too, because they contain truth so partial, so faulty, as to cry out for revision in the light of some such analysis as I have been presenting. They are left out because at this stage of your approach to law your common sense is rather in the way than otherwise. Let me here say only this about rightness of the law, that if most people did not stand behind the officials, however passively, there would be little law to talk about. That if most people did not most of the time when they looked at a rule look to its purpose, as well as to its exact and narrow form, and fit their conduct roughly to that purpose, then the officials would have a burden on their hands they could not bear. And finally, that if most people shaped their conduct really with reference to the law and to their legal rights, for any serious fraction of their time, rather than with reference to the patterns of action, the patterns of thought, the standards of judgment which they inhale as the social atmosphere they breathe, then life in our society would become unlivable. Lawyers are lawyers because they alone among men devote themselves with some constancy to studying out what courts are going to do. And if there are people more unpleasant to deal with professionally, who are they? Courts affect people quite directly then, by their action taken in individual disputes. Courts affect people indirectly because to some extent people concern themselves ahead of time with what courts may do to them or for them. But whereas people are only incidentally concerned about the courts, the lawyer is professionally concerned. He is the point of contact between the people and the law official. And as an advocate, the lawyer is interested in the work of the courts in individual cases. This is his oldest job. This is still a most important job. This is the job which in England is the sole business of the most respected portion of the profession, the barrister. But as business counsel, the lawyer is interested rather in this indirect effect of the work of legal officials which I have just described, in anticipating what the courts might do, and in shaping his client's conduct to his client's desires in view of that anticipation. And this is a phase of law practice which is becoming of steadily increasing importance in this country, and of transcendent importance in this city. I stop at this place only to call your attention to one fact. It should be clear even to the blind, that the work of business counsel is impossible unless the lawyer who attempts it knows not only the rules of the law, knows not only what these rules mean in terms of predicting what the courts will do, but knows in addition the life of the community, the needs and practices of his client, knows, in a word, the working situation which he is called upon to shape, as well as the law with reference to which he is called upon to shape it. It has seemed to some students in the past that they had come to law school to learn the law, and that the law was made up of legal rules and nothing more, and that all other matter was irrelevant. was an arbitrary interference with their proper training for their profession. I have been told by some that social science was for social scientists in the graduate school, that what law students wanted was the law. I have met with resentment, sometimes bitter, at the so-called cluttering up of our law curriculum with so-called non-legal material. If I have made my point just now, it should be clear to you that this is the language of men who do not see far enough beyond their noses to measure even their own job in life. If I have made my point, it should be clear that for most lawyers the job of advocate is half, nay, less than half the job they have to do. Even as advocates, I am prepared to argue. They need, desperately, full knowledge of the facts of the life of the community against which law must play. But when it comes to their task as business counsel, there is no need for argument. The case is clear. The stones speak. What the courts will do means nothing save in relation with how people are to act in the light of the court's doing. For the meaning of the law in life, and in the practice of lawyers, is its meaning not to courts, but to laymen. Your faculty offers, then, no apology for cluttering up the curriculum with such useful data as it can discover as to what law means to those whom it affects. Your faculty knows no other way of making law mean anything. Your faculty welcomes you into a study of law which deals not with words, but with practice, not with paper theory, but with living fact. And if that be treason, make the most of it.